Sorry, I just realized I'm muted. This would help me narrow down how I'm going to approach this. So if you are on a skilled workers visa, student visa, whatever visa you're on, just pop it in the chat and I will see and we'll go from there. Okay, I can see a lot of people. Post-study, graduate visa, post-study, skilled worker, student. So basically today, what I'm going to be doing today is, it's a Q&A. So ideally, it would be people asking questions and I will be answering. And towards the session, some people will be given the opportunity to speak. If they cannot type their questions, I will try as much as possible to also monitor the chats, and we'll give opportunity to people during the session to also speak, to ask any questions that they want, and I will address them as best as I can. So if you have a question, I would say you can pop it in the chat. I will look at it, but I will just give a summary bit of what I will be dealing with today. So we're aware that since the beginning of this year, there's been a lot of changes in the UK immigration rules. I mean, we started off this year with the 1st of January 2024, when the Home Office basically said students are no longer allowed to bring in their dependents. And for those starting their courses on the 1st of January 2024, then we moved on to the increase in the IHS fee, which went from 600 and I think about 624. Don't quote me on that. 600 and something, but now the current price is 1,035. Then March 11, new updates came for those on the care workers visa, particularly those on the code 1465 or something. Sorry, give me a second. Just trying to get that code. Basically, if you were a senior support worker, 6145 and 6146, basically saying that they can no longer bring in dependents. And there's been a lot of frenzy regarding that. People are unsure whether how it would affect their current situation. So today's session is expected to be interactive. I don't want to be the one talking, to be fair. I'd rather if people speak and then I listen and then I answer as we go on. So if you have a question, I would say you can either raise your hand on the chat box thingy, or you can pop in the chat and I will look at the chat box and I would answer. So this is where I would say the floor is yours. Take advantage at this point.
Hello.
Okay, so can I ask my question?
I would say, can we please let's do this orderly. So I would prefer if you raise your hands and I will call your name and then you can speak, or you can put your questions on the chat and I will answer. But when I say raise your hands, I don't mean raising it on the chat, because if you raise it on the chat, there's no way I can see it, I'm being honest. All right, let's start with Glory. Hi, Glory.
Hi, Omotolu. Hi, everyone. Good evening. Thank you for having us tonight. So I'm currently on a skilled worker visa under the healthcare version. I don't know what it's called. Basically, I'm on a care visa. And I know that there's this sort that says that, oh, I have to work with my sponsor for 40 hours, but then I can work elsewhere for 20 hours if it's in the same occupational code or if it's on the shortage list. So with that statement now, because I have it in my head that I can work elsewhere, like I can work in any other industry that is not care, as long as it's on the shortage occupational list. But some people have said to me that it has to be care, like just care. So do you have an idea on if it's strictly care or I can diversify as long as it's on the shortage list?
Okay, so it would be the latter. That's the answer to your question. You can do additional 20 hours either during the same role you're doing at a different company that offers that same role you're doing, or you do 20 hours on any of the jobs on the short sorry, just realized I'm muted. So you're not restricted to just the care sector. It's any
Okay.
job on the shorted occupation list that you can do, but it's just 20 hours. That's it.
Okay. I just wanted to confirm that because I had discussed it with somebody else and then they kind of discouraged me and said it had to be care. Thank you very much. That's one. Then two, I'm sorry. The second question is recently I found out that on the skilled workers visa, there is something that allows you to bring your partner, to sponsor your partner rather, as long as to sponsor your partner even when you're not married. I found out about it like yesterday or 2 days ago. Like even when you're not married, um, the two things is either you've been in your relationship for 2 years and have been living together for those 2 years, or in those 2 years, or if you've been in the relationship for 2 years and can prove, but you can't live together, maybe because your culture doesn't allow it and things like that. But you have to be able to prove that you haven't been, sorry, you have to be able to prove that you've been dating for those 2 years. And when I read online, some people were saying that because I checked some of the categories or some of the things that you would need to show as proof, and I saw that that you're supporting each other financially. So what kind of proof can you have for that? If you're not sharing bills or anything like that, what kind of financial proof will you have to provide for that?
Okay, so for that question, Gloria, you can show, so if you guys have a joint bank account, so basically a bank account that's in both your names, you and your partner, that would work. If you can show pictures would work ideally, but those pictures have to be maybe if you took trips together, then also if you were potentially sending each other maybe money for lunch or something, you can your bank
Okay.
statement can show that. Um,
Okay.
Ideally, because now the home office are a bit strict in terms of showing that you guys are living together like you're married. So most times they would say if you have a tenancy agreement and you guys were like, maybe the tenancy agreement were in both your names, it would ideally show that both of you were living together. That would be a good proof to show.
Yeah,
Because it's
but
spanning
like no,
across
the
two
couple
years.
isn't living together. I'm sorry.
Yeah.
The couple
Yeah, but
isn't living together. So it allows them if they cannot live together. But like they need to show other proofs, like maybe you're supporting each other financially, aside from pictures. So that's why I was wondering, like what
well,
you
that's
can
the
do.
thing. It would ideally be very difficult to show that you guys have been in a relationship for 2 years and your relationship is similar to that of someone that is married. Because if you see what the rule says, you've been in a relationship for 2 years, like you were married, that kind of thing. So basically, things that would more or less show that would be typically like I said before, if you had a tenancy agreement that was in both your names, or you had joint bank statements or letters that were coming or bills, your bills were shared in both your names. Typically, those are the kind of evidence that will be strong enough to make that application go through. You can put
Oh,
other ones, but it may not necessarily be as strong as you put in your like statement that would show okay you are living together like a couple. So things like
mm,
photographs ideally should be okay, but it's just how strong the evidence is that would matter, and
mm,
if the office would buy the idea that the two of you are truly in a relationship and you guys have been in a relationship for the past 2 years and you've been living together like you are a married couple.
fair enough.
Does that make sense?
Yeah, thank you.
All right. Okay, so Richard, I will take you now.
Okay. Hi, Omotolu. Thank you so
And
much for taking this session. So in my case, I'm a dependent. My wife is the student. And so unfortunately, we've been caught up in all the March 11 stuff. I work in a care home right now, and
okay.
my visa expires at the end of the year, towards the end of the year. So my question is, my company says, yes, we will sponsor you. So what is the likelihood of me being able to keep my kids here that's under my sponsorship? Because I understand there's somewhere that says the exceptions if they're below 18. They're both below 18. And then can my wife now maybe take the post-study option so that we can also remain as a family?
Okay. So in your situation, you currently work in the care sector.
Yes, I do.
What is your current visa status, if I can ask?
We're still on the student visa, so I'm a dependent. Yes, but
Okay.
yeah, but my employer says we will sponsor you. Yes.
Okay. So because of the new rules that came into play, what is your job role? Are you
Support worker.
you are a support worker, so
Yes.
that would fall under occupation code 6145, typically.
Okay.
So with the new rules now, unfortunately, you wouldn't be able to add your children or
Okay.
your wife as your dependent if you were to move on to a sponsored position at the moment. So in your situation, what I would advise is for your wife to actually do the post-study, because that way she can still put your children as a dependent. And or you basically can speak to your employer and see if it's possible for them to sponsor you on a different occupation code that allows you to put your dependents.
Okay. All right. Thank you.
Does that make sense?
Yes, it does. Okay.
Okay. Chiamaka, I will take you.
Okay, yes, thank you, Omotolu, for the opportunity. I'm a student, I'm under student visa, and I know that prior to this new rule, it's usually easy to get sponsorship under the care visa. But then I just want to know your suggestions. Are there other skilled work that are easier to get, just like the care work that someone can switch to, aside from the care work? Yeah, so that's my question. When someone doesn't want to consider the postgraduates routes, what other suggestion can you offer? Like, that's my question. Thank you.
Okay. Chiamaka, your question is, I like the fact that you said a suggestion, because this would be a suggestion. At the end of the day, I think it just depends on what you want to do and your financial situation. Now, because you're currently on a student visa, ideally, what I would usually tell clients is take advantage of the post-study. And I understand the fact that a lot of people want to move into the care sector because they see that it is, in quotes, the easiest route to get like a skilled workers visa. But given the immigration rules that have come into play in terms of those on the job occupation code for 6145, that's as carers, care workers and home carers, and 6146 for senior care workers. So typically those two occupation codes can no longer bring independence if they make application for skilled workers visa after the 11th of March. But you can still be employed in the healthcare sector on a different occupation code that would allow you to typically bring in your dependents or any other occupation code on the job shortage list. Or you can get like a skilled workers visa depending on what you studied in school. You can take advantage by making job applications to companies that potentially can sponsor you. Now, in terms of whether it is easy, I mean, to be fair, to get a job in the UK generally is not the easiest thing to do, if we're being honest. But I think it just depends on how far and wide your applications have been. You'll be making applications. So I would say you could, I don't know what you studied in school, you could take advantage of your post-study visa and then use that period of 2 years to, look for something in the fields that you studied and potentially with an employer that can sponsor you, so that you wouldn't be caught by the rules of this whole care, the old care and the dependence route. So it would be a personal decision in terms of what you want to do, but I cannot tell you for a fact that this is the job role you should be applying for that would easily get you to get like a skilled workers visa, because I don't think it's something that it's that easy. If it were easy, then everyone pretty much would be on a skilled workers visa at the moment, which is not the case. I hope that clarifies your inquiry.
Yes, very well. Then finally, recently I got to know about this exemption for what they called new entrants into the labor of market. So please, could you throw more light on it? Thank you.
Sorry, new entrants into
the UK labor market. Like there's an exemption for them. Yes, so please, can you just throw more light on it?
Okay. So the new entrance visa is basically one that allows those who are so there's a list of people on that list. So it will be if you're under 26-year-old, if you are if your visa was your previous leave was a student visa, or you graduated not more than 2 years, not typically not more than 2 years. And then there's a list of other criteria there. I think if you were maybe in a role that you were studying to maybe get into a regulated profession. There's another one for those in the sciences. There's a list of science courses as well. So typically for that new entrant visa, if you fall into one or more of the criteria on that the eligibility criteria for that visa, the implication will be that you don't necessarily have to meet the general skilled workers visa threshold. Now, as you're aware, come April 4, the salary threshold for a skilled workers visa would be 38,700. That's moving from 26,200 to 38,700. So the implication of that would be if you were a student before, maybe you were a student now, and then you got a sponsored role. So you can tell your employer that they should mark you as a new entrant, because typically you would fall into that criteria. Now, what would happen is for the salary threshold for that new entrant, I think at the moment, come April 4, it would be 30,960. That's for new entrants, which is typically below what is going to be 36,800. Now, if you were a new entrant in that scenario, what would mean is the figure that you would ideally have to meet would be either 30,960 or the going rate for your occupation code, that is the role that you are being employed for. So let's say, for instance, if you're employed as maybe you're employed as, let's say, a lawyer. So typically it's going to be that 30,960 or 70% of the going rate for the job role that falls within the occupation code. So as a new entrant, you will be able to take whichever is higher. So that would be what you would come under. So you wouldn't have to be, you won't be caught by the rules of the general 36,800 that is to come into effect April 4, but you'll be caught by that with 30,000. So I think the idea is to reduce the salary threshold that ideally you would have been entitled to meet. So the new entrants just give you that leeway to get like a discounted like rate. Do you understand? As opposed to you meeting that full salary threshold. Does that make sense?
Yes, it does. So that means with that discount, I can be able to sponsor my dependents, right?
Yes. As long as you meet the salary threshold salary, the salary limit for that bracket, you should be able to come on. You can sponsor your dependents. You can put them under your visa, because typically it's tied. So the new entrance is tied to your skilled workers. Do you understand? It's tied to the skilled workers visa. So it's just for your employer to take, oh, you're a new entrant, and it allows you to be a new entrant for the period of just 4 years. You can be for just the period of 4 years. So it's just for you to be able to start off like on a salary that is below the typical threshold salary for the general tier 2 I'm sorry, tier 4, whatever. Yeah, tier 2. Yeah, that's tier 2. Skilled workers threshold. Yeah.
Okay.
Does that make sense? Do you understand?
Yes, it does. Thank you so much.
But you know what? Just check online because everything is online. The criteria is actually online. If you go online and you type new entrant visa, you would see the criteria. They will list literally everything. You are under the age of 26. There's another one for your previous leave was either a student visa or the postgrad, and you've not graduated from school more than 2 years ago. So it's on the list. If you check it, you just check which one do you fit into, and you only need to meet one of it, not all of it. So if you cannot meet the first one, check the second one and the third one and the fourth one. If you meet one of it, you should be fine.
All right. Thank you so much. That will be all.
I will take you, Lekon.
Hello, good evening. Hello. So my situation is a little bit different. So I'm not even in the UK yet, but I don't want to get caught up in the whole get someone to sponsor you. Yeah, the 2 years post-study is attractive. And I'm inside the tech industry. So the last thing I want to do is do another care job just to remain and do all jobs. So what's your own take on even considering the UK? Do you think the laws favor new entrants or new people coming to the UK on a postgraduate visa and trying to get a job and all that? So what's your take on that? So it's better you don't even put your head or step into it and just find a better option and just go in there. So that's just my question.
Thank you. So you mentioned one thing. You said you were in the tech space. So for those in the tech, what I usually would advise for people in tech is to see if they can take advantage of the global talent visa. So that visa typically allows those that can show that they are potential leaders or they are leaders in their field. And it allows them to be able to get an endorsement from the endorsing body and make the application for global talent visa, which allows them to come into the UK to work in the UK. So you could take advantage of that. Now, for global talent visa, you would have to show that you are like you meet the threshold for the exceptional talent or exceptional promise, and typically show the endorsing organization that you are like top notch. You are the best of the best. There's no one better, or there are people better than you, but at least you are on that level of the best, or you have the potential to be the best. So that would mean showing like documents of things that you've done throughout the course of your career that maybe allows you to stand out than the ordinary person that was probably in your field. So if you get the endorsement, so that would give you the opportunity to actually apply for the global talent visa itself. So when you make that application for the global talent visa, if the Home Office goes through your documents and you meet basically like all the threshold and all that, typically you can come into the UK on that visa. Now, you could also go through the route of the student visa, but as you're aware, for students, they can no longer bring in their dependents from the 1st of January. So typically what would happen is in your situation, if you were married, you wouldn't be able to bring your children or your wife to the UK if you were to come here to study. And for people that are students, you still take advantage of the postgraduate visa after you've completed your studies as well. You could take advantage of that. You could also be employed directly in an organization that is willing to sponsor you from Nigeria, and then you just come here directly to work in the UK, skip the process of having to study and just, come here on the skilled workers visa, which typically allows you to work for 5 years, then you can apply for the indefinite leave to remain. 1 year after that, apply for the British citizenship. So like there are different routes and different paths. I think it just depends on what you would want to do and if you would meet the criteria for each of the routes. Do you understand?
Yeah, that makes sense.
All right. I would take Farinde now.
Okay, so the question I wanted to ask is not as regards, sorry, good evening, Omotolu, and thank you for this opportunity. Okay, so the question I wanted to ask is not based on the March 11 rules. It's on the 10-year route to settlement. So I'm currently on post-study work visa. I was the student when we came in. So if you want to go on the 10-year route visa now, and my husband intends to be the next person to study, does it cancel out the 3 years we already spent as being a student and then the 2 years post-study? Does it cancel out that one and then it will now start?
Sorry, could you repeat your question again? I'm sorry. Can you repeat your question again?
Okay, so I came in as a student and we are currently on post-study work visa.
Okay.
So my question is, if we want to go on the 10-year route,
Yeah.
and my husband is the one that intends to study next, I don't want to go for a PhD, does it cancel out the 3 years I already the study, the 1 year master's, and then the 2 years post-study? Does it cancel it out, or it just continues reading?
It continues.
Oh, it continues.
So the idea of the 10 years, the idea of the 10 years long resident route is for you to actually be here in the UK legally for a period of 10 years. So every single visa route you've taken to count to 10 years here in the UK counts. So your student visa, your postgrad visa counts. If you were to switch as a dependent to your husband's visa, that counts as well. Typically, it's just to show that you've been here legally for the past 10 years. That's what counts. So everything counts.
Okay. So it means that at the end of that 10 years, I would be the one to apply, or how? Since I was
So
like
when you meet the 10 years, when you can show that you've been here in the UK continuously for 10 years, then you can apply for indefinite leave to remain.
Okay. All right. That's my question. Thank you.
No problem.
Thank you.
I will take Paul.
Hello, good evening. Thank you for having me here. I just want to talk about the current situation I have now. Not directly with me, but with a friend. She's currently on student visa, and she got, I think, this COS thing for care. So I think because of the agreement between her and employer, there was a dispute. So she had to withdraw her application so that she can still continue to be on her student visa. So I think recently she just got a mail from the Home Office that her application has been approved, has been successful. And so she requested that it should have been withdrawn. So currently now, her application for the COS, the Tier 2 visa, has been withdrawn. And she had already had an employment with the care home office already. Does that mean that the student visa has been cancelled, and can she now switch back to post-study?
Okay, so typically what happens is when you make an application and you submit an application, let me start again. So if you come here as a student, and then you make a subsequent application, what you are saying is you no longer want to be on the student route. You want to now move on to another route. So you can't come back. You're moving on. You have to move forward. So the minute she made the application, the implication of that is that she was moving on to another route. Now she's gotten it on that application, which obviously automatically canceled the previous one that she has. So at the moment, she would be on the skilled workers visa. That's her current visa status, not the student visa, and she cannot go back to the student visa. Does that make sense?
Yeah, makes sense. All right. So she has to look for another employer who can give her the COS because she has lost the sponsorship with the current employer now.
So typically, if she's lost the sponsorship with the current employer, what would happen is she wait for the Home Office to actually send her, well, not wait, but typically what would happen is the Home Office will send her a curtailment letter. In that letter, what they will be telling her is, your employer has told us that you no longer work with them. As a result, you have 60 days to either switch your visa to another visa or leave the United Kingdom. So at the moment, what I would tell her to do is try to look for, it's either she moves on to another kind of visa, which can be any visa category. She doesn't necessarily have to move back on a skilled workers visa if she cannot find it. If she can afford it, she can go back to student visa, but she can't do the postgrad because she didn't move from student to postgrad. And for postgrad, your previous leave has to be a student visa before typically you can move on to postgrad. So she can decide to find another job So at the moment, I would say she should find another job as soon as possible, a job that can potentially sponsor her, or
Okay.
she can adopt any other. She can try and see if she can make any application where she meets the eligibility criteria for another visa category. It could be student, it could be global talent, it could be if she's married to somebody that is a British citizen, she can be a dependent under that person's visa, or someone with a settled status, she can be their dependent. So she needs to see which of the visa routes, and if she meets the eligibility criteria for those routes, she can go on those ones. Does that make
All right.
sense?
Yeah, sure. All right.
All
Thank you
right.
very much. Yeah.
You're welcome. Farinday, I think, I don't know if you still have, if you wanted to ask another question, but I see your hand still up.
Sorry, I thought I lowered it. I'll just do it now.
All right, I will take Ololade.
Hi, Omotolu. Hi, everyone. Thanks for doing this. I just wanted to ask more like a further question to Richard's question. So I understand the March 11 update very well. And I know that it's something called exceptional dependent applications. So I'm just wondering if you could like give instances of circumstances that could fall under that.
Okay. Well, to be fair, at the moment, I wouldn't be able to give you an example, because the reason is because exceptional and compelling circumstance depends on each individual circumstance. For instance, let's say you gave birth to your child, or let me just, if you gave birth to your child in the UK, which the rules actually even cover, it's difficult for me to give you one example of what would fall under the exceptional, compelling, and compassionate circumstance, because that's ideally at the discretion of the Home Office. It's not something that you can just say, oh, if I make sure I show this one and this one, then my visa application will fall under the exceptional dependent application. So ideally, you would have to show something that's like the word says, that is exceptional and compelling, honestly. That's typically what the application will be. What an example, I'm not now, because even if I were to throw in one example and somebody were to make a visa application based on whatever example I give, I cannot guarantee that that application will be successful, because it's at the exceptional dependent applications is at the discretion of the Home Office. When they look at your case, look at the evidence that you have, if they feel that, okay, you've showed good reason why you cannot leave the UK, why you need to remain in the UK with your dependents, then that would fall under that ground. So it's on a case-by-case basis. I don't know if that makes sense. I hope that provides you a bit of clarity.
Yes, thank you.
All right. I would.
Sorry, please. Hello, ma.
Hi, I don't know who is speaking.
Thank you. I'm Hayodele.
Hi.
Sorry, thank you. Sorry, I missed out from the last point you made, and I heard it very well. I heard you talking about you're independent and then you are not allowed to switch to the main applicant. You could give a reason why you have to be in the UK. So
yes, I was talking about the exceptional dependent application. I think Ololade asked me to give an example of what would fall under that category. And I did explain that I'm unable to do so because it's usually on a case-by-case basis. Now, that exceptional dependent application is at the discretion of the Home Office, depending on the information that's been provided to them that shows that there are compelling reasons why your application should be granted and should be considered. So things like that, there's no one example that would fall into that kind of category. I think it just depends on your personal circumstance and what you're trying to explain to the Home Office as to the reason why you should be allowed to remain in the United Kingdom.
Okay.
Do you understand?
Yeah.
Okay. Let me look at the charts for a second.
Sorry, before you look at the chat, sorry, please.
That's okay.
Thank you. Now, like those exceptional cases, can you just give us maybe 1 or 2 examples?
That's literally what I just said. I'm unable to provide an example. Do you know why? If I say one example now, and somebody goes to make an application and makes something up and say, oh, because Omotolu has said this example, then it's probably going to be accepted by the Home Office. Let's just roll with that example and tell the Home Office this is this and this is what is happening. The thing is, if I give you one example now and you make the application, there is no guarantee that application will be granted. That's why I said it's important to show evidence. So if you are saying you have an exceptional and compelling reason why you should be allowed to remain with your dependents in the UK, if your occupation code falls within 6145 and 6146, be sure to provide evidence. Maybe evidence of that exceptional circumstance. Now, the Home Office will look at it and say, okay, we look at this application. Yeah, this person should be allowed to stay here and grant it. Or they may look at it and say, well, you stated all these reasons and we still don't feel like, you meet that threshold, so we are not going to grant you that visa application. Okay. It's at the Home Office discretion. I can't give an example because whatever example I give here today, there's no guarantee that it's going to work.
Yeah. Okay. Thank you.
You're welcome.
Clear.
I'm trying to see. Okay, I think I have managed to answer as much. I'm going to go on the chat now. Olu said, hi, Omotolu. Thanks for sharing this information. Please, can you give an example of job codes within the care or health system that can allow an applicant to sponsor their dependents? I don't know all the job codes off the top of my head, if I'm being honest. If I give you a job code and you go and check, you probably will never see the code on the list, if I'm being honest, because I don't know everything. But all I know and all I can tell you for a fact, if your job code is 6145 and 6146, you cannot bring your dependent in the United Kingdom anymore because you'll be making your application after March 11, 2024. However, please bear in mind that it is not just only the health and the care and health system that is on the shortage occupation list that you can make applications and bring in dependents. There are other job codes that if you were to meet, if you were to be employed within that sector, you can bring your dependents. I think it's just depending on you just going on the list. So there's a shortage occupation list, which is now going to be tagged, I think the immigration salary list or something like that. They are changing the name, Sha. But the idea is for you to go on there, look at the codes there. As long as it's not 6145 and 6146, you can bring dependents. But if it is 6145 and 6146, you cannot bring dependents. So this is where I would say to do your research and check the job codes, because I don't know all the job codes off the top of my head. It's a lot of job codes, a lot. I cannot tell you this is the one that if your employer should pick would work. Just go and look there. And if you have a good relationship with your employer, you can speak to them and tell them, okay, can you just employ me with one of these job codes that is not 6145 or 6146. But that's about it. I can't really give a specific example of a job code. Chinyere wrote, the global talent visa criteria is not even looking like it's easy to pass all the threshold. Well, people have passed it and people are on it. It's not easy, but it's not like it's not doable. It is doable. I know a lot of people that are on the global talent visa. I can tell you for a fact. And I know people that I have also assisted with, doing the meeting the threshold and the criteria and making the applications as well. So it's doable. It's not impossible. It's very, very possible. Gloria said, how many times can one apply for post-study? For example, one finishes a master's program, then apply for post-study visa. Can the same person apply for post-study visa after a PhD program? You know why I like this question? Because I was having a debate with a friend of mine about this, whether or not you can apply twice. Now, I would say this. If you go online and you check for whether you can apply for the post-study visa twice, what you are going to find is a lot of university websites saying that, oh, you can only apply for the post-study visa once on the graduate route. I know the graduate route basically combines both whether you're studying as a master's student, as an LLB student, or you're studying as a postgraduate, that's PhD student, they would say you can only do it once on that graduate route. If you go on the Home Office website, there is nothing in that website that says that you can only apply for postgraduates once. However, do not quote me on this. I have only seen people apply for postgraduate visa once. I have not seen people apply for it twice, but you can try. You can do a PhD program and try to apply for the postgraduate visa after that PhD program, because that one will allow you to get 3 years post-study. Whether or not the application will be granted, I cannot tell you, because I have not seen somebody and I've not handled a case where I've done it twice for a person. I've only done it once. And that is as far as I can say regarding that inquiry. But like I said, do your research. That's the best I can tell you at this point. Just do your research. Then Ade said, does the 2 years post-study count towards the 10-year route? Yes, it does. It does count. Taiwo said, good evening. Please, I want to know if NHS carers are affected by the March 11 policy if they secure COS and apply for a visa with dependents after March 11. For Taiwo, NHS carers, if the occupation code that they are employing you as is 6145 and 6146, then you will be affected. If it is not, then you are not affected. I hope that clarifies. Amarachi said, please, I want to ask, Mr. A was on a care visa with his family, but however, his sponsor license was revoked and he has gotten a new COS. Please, I want to ask if he is going to switch visa again together with his family, or will he switch alone? The first question I'll ask Amarachi is if Mr. A, you know what? Actually, Mr. A was sponsored already, so he was already en route before the rule kicked in. So if he got a new COS, he can switch with his family, because it would fall under one of the examples on the March 11 update. Now, let me explain. There was an example on there. I'm going to read it out so everyone can learn from it. Okay. So there's one example that says, migrant A has been sponsored as a care worker with their partner and child since 10 January 2022. Their dependents can continue to apply as such. The meaning is that if you started working as a carer before March 11, if you were sponsored as a carer, whether you were on 6145 or 6146, before March 11, 2024, and your family came with you, you can still continue on that route. The rules does not affect you. That's the answer to that question. Taiwo says, I think Taiwo has asked this question again. I want to know if NHS care or healthcare assistant will be NHS. I believe I've answered that question. Amarachi, do you mind if you speak, if that's okay? If you don't mind, can you unmute and ask your question directly?
Okay, hi, good evening, everyone.
Hi.
Thanks, Omotolu. Yeah, what I'm trying to find out is, it's not about switching if they can all cross. You know, usually they said when you have a COS and you're getting another one, you don't need to make application with your dependents at the same time. Only you can switch. So that's what I'm trying to ask. Like, since he has always had this COS with the dependents, are they all going to switch again, or the dependents remain and then he continues to switch? That's what I'm asking. In the application.
Okay, if okay, so basically what would happen in that instance is the dependents don't have to switch immediately. However, I am mindful of the fact that it says here that the care visa, the sponsor's license was revoked. Now it depends on the limit of time that your dependents like have on their BRP. So if their BRP potentially was ending, let's say 2026, and then subsequently Mr. Hay got another COS sponsoring until 2028. Typically, what you would say ideally is that they don't have to switch immediately. However, they would have to switch at some point because 2026, 2028, I mean, there's a two-year time gap. So before their current visa runs out, they need to have switched under Mr. A as a dependent before their current visa runs out. But typically, they can still not make the application immediately. You don't have to switch immediately. You can still wait for a while before your dependents will join you if you remain applicant. Does that make sense?
Okay, not minding that the first sponsor's license was revoked.
Now, ideally, I would advise that if it's possible for them to switch as soon as they can, they do. But if it's financial circumstances not allowing them to switch, they can wait it out for a bit, but they should make sure that they switch before that current visa is either revoked or before that current visa expires. That's what I would advise them.
Okay,
Do you understand?
thank you.
All right. Yeah, I think I've answered all the questions. Yay, me. Look at me. Oh, yeah, I have answered all the questions. Great. Okay. What I will be doing is now I will be explaining the March 11 update to everyone so that you get a bit of context. Now, the first thing to note is this update affects two occupation codes. The first one is 6145. That's those employed as care workers and home carers. Or 6146, that's senior care workers. Now, if you go online to check the list, there would be, it would say the first, like it would tag 6145 as care workers and home carers, but there are other job titles that also fall under the 6145 that may not necessarily be tagged, maybe care workers and home carers. Do you understand? So we have support worker, we have I think there's another one for home care assistant or something like that. So typically anyone that falls under that job code would be affected by the rule. Same thing with 6146. So it's important for you to actually go and check what job title falls under the 6145 and 6146. If you find out that your role, the role you're being sponsored for falls under that threshold, the implication will be that you can no longer bring your dependents if you can no longer have dependents on your application if you make your application after 11 March 2024. Now, I will go back. Don't worry. I will go back to the hands that are raised. I don't even know. I don't think I can even see everybody's hands that are raised, if I'm being honest. So at some point, Dami, I think you're going to have to help me. But let me finish what I was saying. 1 second. So if you made the application as a skilled worker if you made the application as a skilled worker in the healthcare sector and your job code was 6145 and 6146 before March 11, you're fine. Your dependents can still stay with you subsequently. Now, there's one more thing that I think people don't also pay attention to in relation to this rule. Let's say, for instance, you were a student, and typically students cannot switch into another visa category until they've completed their course of study. Now, if you were a student and then you subsequently got you were with your dependents and you subsequently got employed as a carer under the 6145 and 6146 job code, and your dependents are under your student visa, and you made the application after 11th of March 2024, unfortunately, your dependents can no longer be your dependents in respect to your skilled workers visa for those job codes. The implication will be that your dependents either find another visa category to move to that allows them to stay here legally in the UK, or they have to leave the United Kingdom. That is the implication. It also applies to people that are on skilled workers visa for maybe a different job entirely. And then subsequently, after March 11, they got sponsored as senior care worker under the 6146 job title, or as a care worker under the 6145. and they had their dependents when they were still on the skilled workers visa for that period of time. So as long as the new application that they are making for that job code title was not the same one that they were on before, they will be affected by the rule. So let's say I was employed as a nurse in 2022. And then subsequently, I lost my job and I came with my dependent and I lost my job. And then I got another job today. Today is the 17th of March. That wanted to sponsor me as a senior care worker. That's under the 6146. I have my dependents before under my skilled workers visa whilst I was a nurse. The implication of me now making a new application under this job title would mean that my dependents can no longer stay with me whilst I'm on that sponsored under that rule as a senior care worker. That is the implication. Do I think it is bad law? This is a personal opinion. Yes, I do, because it is unfair for me to have to tell my precious dependents to go back home. Why? I think it is bad law. I think people are going to fight, and this is probably going to go to court. Whether or not it's going to be successful in judicial review, I do not know. But this is the law, and that is what it's saying. So those are things that we need to pay attention to. I will continue answering questions that may help
So
me.
I help you read some of the questions in the chat, so just it helps you a bit, subject to whether or not you want to, or you want me to read, or you want to continue reading. So let's just.
No, please go ahead, because I don't think I can even see people raising up their hand at this point.
Okay, so there's one question from Ade, and he said, presently on PSW, which is post-study, which expires the ending of this year. If I apply for another master's program, can I include my dependent?
Sorry, can you repeat that? The person's on the PSW.
So he said, I'm presently on a PSW, which expires the ending of this year. If I apply for another master's program, can I include my dependent?
No, you cannot. Do you know why? Because 1st of January 2024, that law that says students that are starting their course on or after the 1st of January can no longer bring dependents would affect you. So you cannot, and your dependents won't be able to come under your visa as a student if you were to make a subsequent application under the student visa. That's the answer to that question.
There's another question by Taiwo, and he said, he or she or they said,
You want to tackle about on a drink? It's cheaper. Or do you want Friday? That's a meal.
Depends. Oh my God.
Who that is, well.
I don't have a problem eating chips. You know that.
Okay. So I've muted all. Omotolu can check if your mic is mute. Okay. So the next question by Taiwo is, good evening. Please, I want to know if NHS carers, that is healthcare assistants working with the NHS, are affected by March 11 policy if they secure COS and apply for visa with dependents after March 11. Should I come again?
Like I said.
Okay.
That's like I said, it depends on what your job code is. Now, please, let's understand something. It's not affecting all the job codes in the healthcare sector. It's only affecting 2 of the numerous job codes in the healthcare sector. And that's just the 61445 and 6146. If your job title does not fall in that code, you're fine. You can bring your dependents. There's nobody that is going to stop you from bringing them. But if it falls under 6145 or 6146, and you make the application after the 11th of March, 2024, you would be affected. Unless you were en route before then, and your dependents were here, then you will not be affected. But if you were not sponsored before March 11, 2024, and then you got a job under the 65 or 6146 job code, you would be affected and you cannot bring your dependents. That's what the law is saying. It's as simple as that. It doesn't go past that.
There's another question by Amarachi Okoro, and he said, please, I want to ask Mr. A. Also, please, I want to ask, comma. Mr. A was on a care visa with his family, but
I think I've answered that question already.
oh, okay, fair.
Some people are saying they are raising their hands. Can I see? Can I? If your hands are raised, I think.
There's Lola raising. Lola, can you ask your
Hi,
question?
Lola. Sorry.
Yes, please. Good evening. Thank you, Omotolu. I have a question. I'm just going to use myself as an example. So with this March 11 update, so it means that I am the student and I just finished. Our visa is expiring in May, and my husband is working in a care home that has promised him sponsorship. So does that mean that he will have to get his own COS while I also source for my own COS? But our children, how do we, where do we put them since we cannot have dependents? So I think that is just our major concern. That's on one hand. And the other hand is if he is being sponsored, I can take post-study, and I know that if I take the post-study route, I can put my children as dependents. But I don't want to take the post-study route. I'm also sourcing for COS. So how do I, where do we put our children? I think that's our major concern. Thank you.
If you remember when I said something about the exceptional dependence thing, can I ask how old are your children, if I may?
They're 11 and 13.
11 and 13. Okay. So, in your situation, what I would say is if you get sponsored and your husband gets sponsored, the question is, where would our kids go? Now, you can make an application to the Home Office and then fix yourself under the box of the exceptional circumstance, especially if you don't have anybody that will take care of your children and they are minors. Where do they expect minors to go? So if you can show the Home Office that you fit into that compassionate, exceptional circumstance and say, okay, see, this is the thing. I'm on my skilled workers visa. My husband's on the skilled workers visa. We were already in the UK with our kids who are minors. With the new rules, this obviously impacts our family adversely. If you can show that this is going to potentially, like, there's nobody to take care of your kids can't, you don't have anything. If you can show that you don't have anything or anyone that could potentially even take care of your kids if they were to leave the United Kingdom, that typically will fall under the exceptional ground. Whether or not it's going to be accepted, it's at the discretion of the Home Office. You have to show evidence. If you show evidence to the Home Office why your children should not be allowed to go back to their country because you've been the one catering for them, and you can, show that these are things that is exceptional, like there's nothing you can do, and you have evidence to back it up, you can throw in the exceptional grounds there. Like I said, whether or not to be granted, I cannot tell you for a fact. It depends on how you present your case to the Home Office. They would look at it, and if they feel that you meet that threshold of exceptional circumstance, then it may or may not be granted. Do you understand?
Thank you. Yes, please. Thank you.
So before I go to Kemi, let me just read one more question from the chat. So Amaka said, for masters, I believe research masters is an exemption, which could add like dependents.
Actually, yes. Amaka is right. She is right. So it's I think, is it research master? That would be PhD. I think if you're doing a PhD, that typically you can bring, if you're doing a PhD, you can bring your dependents. I think it's for people, there's a level, RQF is RQF 8. But if you're doing an RQF 7, which typically falls within like normal master's degree, I think if your level is not RQF 8, which is for PhD, you cannot bring dependents. But yes, there's an exception. Please check the gov.uk website. Check the gov. I would see everything I'm saying here. Everything I'm saying here, aside from what I've been doing for clients in practice, all the information can be found online. I promise you, if you have a problem and you just go online, maybe if you don't know what to eat, you can type, okay, types of food. You will see options of different kind of food. Checking is if you check, you will more likely find your answer. It is when you see that you're not finding the answer, that's when I would say, okay, you know what, consult with a solicitor that would help you out, that would, you know, point you to the right direction, that would give you advice tailored to your particular situation. But ideally, if you go online, majorly the gov.uk website, it has everything that you need. So you can check it. If you check it, you'll more likely find your answers. But I think the problem is a lot of us don't like to read. And it's not good because you're in a country that, I mean, if you came here to study, you typically told them you can study, you can read now. So pretty much just read. If you don't understand, it's a different thing. If you've read and you don't understand, that's a different thing. But I usually encourage people to try to read first and then ask questions later. Not ask questions when you don't even know what the position is. So try to read.
Thank you. I would give the mic to Kemi. Please, Kemi, you can ask your question.
All right, thank you very much. Good evening, everyone. So my questions are, let me say, two in one. So I have a friend who applied for care visa from Nigeria last year. She has 4 children, and her first child is 18. So her first child was refused. Then her husband, and the younger 3 children were granted the visa. So she went in. Okay, at first I was refused on the grounds that they could not establish the relationship between her and her child. They couldn't establish the fact that she's the mother of the child because she submitted the birth certificate she submitted was from the hospital, not a government birth certificate. So before the visa was refused, she was sent an email that she should provide a government birth certificate. So she did, I don't really understand what she did. She said she got an attestation from National Population Commission. She did DNA tests. She added DNA test result and pictures from when, her first child was a baby, pictures of them together till the girl became 18. And she sent those documents to Home Office and she was refused that the attestation is not a proof, is not a valid government birth certificate, even despite the fact that she added DNA test results and all that. So she went for administrative review, and at the administrative review, the result was the same. They said decision maintained, the girl is still refused. So she now submitted an appeal, and this was October last year. So she's been waiting for response, but she's beginning to get worried that since October she has not gotten any response from the Home Office as regards the appeal, and she's wanting to know that is it possible for her to send an email. I told her that it doesn't work that way. Maybe she said maybe like a reminder email without help. And she's also asking with these new rules, because since the girl did not come with them initially, is there any hope that a daughter might be granted visa, and would she be able to bring her daughter? So what is her chances? She's just worried and we don't know what to do as regards it. Thank you.
Thank you. So for your friend, I would say that it's an appeal. So she can send an email to the immigration tribunal. I can't remember. I think you have an email address, if I'm being honest. I can't even remember the email address off the top of my head. But in terms of whether or not she can still bring that child in, she's already en route before these rules came in. So potentially she would still be able to bring the child. However, because of all the refusal, she's in a bit of difficulty. But like I said, our application is still on appeal, which means she's still waiting for the final answer from the immigration tribunal. So for right now, I can say that all I can say is for her to wait for the outcome of that appeal. And then when that comes in and she doesn't know what to do, let her consult with the solicitor so that they can advise her on what next to do.
Okay. All right. Thank you very much.
No problem.
So I would pass the mic to Faride Oluwatoyin.
Okay, so my question is stemming from the person that asked about the masters, if he or she decides to study again in December. So I was asking this, bringing dependents in, does it affect people that are already here? Like, so if you apply for another masters, maybe in subsequent months, can't you retain your dependents under you as dependents? Because they're already
No.
here. It's not like they're just coming.
Well, no, you can't. Do you know why? Because that rule is not necessarily looking at people that were already here. It's looking at the course start date. If your course start date is after 1st of January 2024, whether or not you were here in the UK before, doesn't matter. It's the course start date that matters. So if you're going to go for another course and the start date is already after 1st of January 2024, your dependents can no longer stay with you. That's the implication of that rule.
Oh, okay. All right. Thank you.
So let's go back to some of the questions in the chat. Ezine said, Place is a dependent on a tier 2 care visa who came in before this rule was able to get sponsorship from her employer. Please will our husband, who was the main applicant, and son still be a dependent?
Yes. Yes, that's the answer. Yes.
Okay. So there's another
Unless
question.
her husband, wait, her husband who was main applicant for what? Hold on. If he was the main applicant, on what visa was he?
So it says, please, if the dependent of a tier 2 care visa who came in before these rules was able to get a sponsorship from our employer, right? Please, will our husband, who was the main applicant, and son still be our dependent?
Isn't it? Have you made the application already for the sponsorship before March 11? First question. If you've made the application before March 11, then you can add your dependent on. If your husband is a student, he needs to finish his course before he will be added. He can make his dependent application, but he will be able to come under you because you were already en route before the rules kicked in, and your son as well, if that is your situation. I don't know if Ezine wants to clarify if that's her situation or if that is what she's asking for.
If I see any other message from her, I would, or from the person.
Maybe if you can speak, that would be great.
I think you already thanked
Yeah,
you.
you have answered it. Yeah.
Oh, okay. Right.
Okay.
So there's another question, and the person is okay, iPhone. Yeah, so my question goes like this. If someone is married to a British citizen and her first 2.5 years ends August, will she still stick to the previous threshold, which she was granted just 5 years for, or she needs to use a new threshold to apply for the second 2.5 years? Also, after the 5 years and doing the life of a British, also after the 5 years and doing the life of a British citizen, does she need to apply for ILR first before applying for the British passport, or she can just apply straight for the passport without applying for ILR first?
Okay, so you're married to a British citizen, which means you are the dependent of a British citizen. The first 2 years ends in August. Will you have to stick to the previous rule? Well, new salary threshold comes out April 4. I'm unable to answer this question because the guidance for that one is not out yet in terms of whether or not it would affect people, like just the way we have the whole March 11 of the affecting people making applications after March 11. So for that one, the one for the salary threshold, because at the moment you are still using the former threshold salary, like, April 4, the salary threshold will be increased. And the idea, I think, is for it to be increased in phases. So I think we're going to have 29K first, and then we're going to have about, I think, 36K, and then subsequently in 2025, beginning of 2025, we're going to have 38,700. And that would apply for usually, I think that figure applies for British citizens or those that want to bring dependents. For if you had a status or you're a British citizen, that salary threshold increase would start then. So if I say I can't say yes definitely that you won't be affected by it, because I don't know at this present moment. But I can tell you that at the moment, I can say regarding your second question, you have to do an ILR first. Then 1 year after your ILR, you apply for British citizenship. But make sure you done the life in the UK test. I think that's what you're trying to write there, life of a British citizen. So you do the life in the UK test for the ILR as well. Do you understand? So I hope that clarifies your question. iPhone.
I think that part got me because I was like, life, I couldn't read in between the lines. So I think the person has another question, and it does. Another question is that my friend has COS with a Kia. Sorry. My friend has COS with Kia and is about to get married to a British citizen. But she wants to find out if she is married and switch to a spouse, the years she has to spend on her COS, can she continue with the spouse visa for the years, or she has to start all over again?
You have to start all over again.
Sadly. So for Amarachi, I don't know if I've read this question before, but what will be your advice to this family? They went from student visa to apply for sponsorship visa, but the Home Office is yet to respond to their visa application. But then they have heard that the sponsor license has been revoked by the Home Office. What is your advice? Should they withdraw the visa application they have put in for their tier 2? If they do so, can they go back to apply for post-study visa? That's tricky.
Yes, withdraw. As long as you've not heard back from the Home Office, withdraw and try to put in your application for post-study. If your current tier 2 visa has not expired, if it has expired, you can, it's a bit of a dicey one. You can make the application. That's a very tricky one, if I'm being honest. But if your current student visa you still have a couple of months on, withdraw the application and do your post-study visa ASAP. I would even say do it as soon as possible. If you can withdraw it today and do it today. Because they've not heard back from that visa application. So, but if your visa has expired, you still have that 14 days leave period. But withdraw it and make the post-study.
I also think maybe in addendum to that, you can always still reach out to the Home Office to know what stage you're.
Speak to a solicitor, because I need more context.
Yeah. I think we should message Omotolu afterwards then for private consultation. I think that is all in terms of like questions. That happens to be the last question. If there's any other person.
My student visa has expired in January.
Okay, is there?
It expired in January. We're in March.
Yeah.
Come and speak to a solicitor. Come, let's have a conversation.
Fair.
I'm gonna pop my email. On the group chat. Send me an email. Let's talk.
So I think, is there any other person that has question or questions for our guest speaker to resolve? I think
All right.
for now you've done justice to. Oh, we have a question. Gina. Gina, please can you unmute your mic and ask your questions? Gina, you can unmute and ask your question.
Is Gina still there?
Let me see if I can ask to unmute.
One question I get, I think Story has asked, okay. One question I get often is, can someone continue on the path to citizenship if he switches to a dependent visa after marrying a British citizen? I'm sorry. Do you wanna type your question, Gina? And sorry, is it possible for Story to speak, if that's okay? If you can, if you are not, if you don't mind.
Yeah, I can speak. Yes, I can speak. Yeah, I've gotten a couple of questions from some friends, and these are friends who are already on a skilled work visa, and I've already done like a couple of years on the skilled work. Can they continue on the path to citizenship if they suddenly kind of get married, or if maybe the company they're currently working with, goes bust, and they're trying to now continue that path to citizenship by maybe they've found somebody to marry and they get married to a British citizen? Can they now continue their kind of 5 years and then apply to the ILR, or do you have to kind of start all over again for that process?
Well, if they switch to a dependent status because they married a British citizen, it will start from the beginning. This is because their route has changed. They're no longer on the skilled workers route that would say 5 years ILR. You switched route already. You're now on the dependent route. So you would typically be starting over again. Does that clarify?
Yes, that's fine. There was an argument that someone gave. I think I'm not very confident with the regulations and the law, but I think you have to be maybe totally be in the UK for a certain number of years before you can apply to apply for this for the British passport. So I may be wrong on that, but do you have to be in the UK for a certain number of years before you can apply, or it has to be conditional based on the visa that you're currently on?
Well, okay. So this and to get ILR and to get British citizen, there are different routes. So typically, if you're on a skilled workers visa, you'd say 5 years. If you're on that visa for 5 years, or you were dependent of someone on the skilled workers and you guys were there for, actually, you can show the 5-year route. Then you apply for ILR after 5 years. And then after one year after the ILR, you apply for British citizenship. And there's one for 10 years long residence route. That's typically saying every visa route you've been here continuously. You can show you've continuously been in the UK legally for a period of 10 years. That one also would take into consideration every visa route that you've been in. So your student visa, your post-study visa, if you switched to skilled workers visa, or you switched to another type of visa category, and everything stretched out to 10 years, then you can apply for ILR. 1 year after ILR, you get your citizenship. Now, if you are a dependent of a British citizen, typically you would have to be here for a period of show that you've been here for a period of at least 5 years, and then after that, you apply for the ILR, and then 1 year after British citizenship. So like there are different ways to get. If you're on global talent visa, there's a period of time as well you need to meet to apply for ILR and then British citizenship. So there are different visa category, different routes to attain that final place of being a British citizen. You just need to meet the criteria, meet the number of years that would show that you need to be here in the UK, and then apply for your ILR. 1 year after ILR, British citizenship. That's typically how it works.
Thank you. We have Olu. Please can you unmute your mic to ask your question?
Thank you, Danny, and thank you, Omotolu, for the time so far and the information you've shared. I just want to ask about a baby that is born after an application, a successful application for a Tier 2 visa. For that kind of baby, would you, the route to citizenship for him would come, I'm asking this because I really don't know. Will the route to citizenship for that baby be after the ILR is gotten for the parents? And then if you have other children in that mix as well, do they need to get ILR before getting the British citizenship? Or once the parents have ILR, they can just file for their own citizenship without them particularly getting the ILR?
So tip can apply you can apply if you get ILR, you can apply for, and your family were under you, like during the period, you can apply together for the ILR. Do you understand? Now, for children born in the UK, there's a route for those who were born in the UK and can show that they've been here for at least 7 years. For children, this is for children. So let's say, for instance, you came in here as a student. So and you gave birth as a student here in the UK, your child was born here. And then you proceed to doing masters. I mean, after your student doing your LLB, you did you did LLB for, let's say, 4 years. And then you did masters for 2 years. But your kid was born here in the UK. Do you understand? So 4 years, 2 years, your child is 6 years. And then post-study, that's 8 years. Now, when your child clocks 7, they can apply for ILR if they were born here in the UK.
Okay.
So they do that, but for you, it's a different thing for you.
Oh, okay.
But your child can apply if they were born here in the UK and they reach from age 0 to 7, they can apply for ILR in that instance. Does that make sense?
Yeah, that makes sense. But as a parent that already has ILR, and the fact that you now have settled status in the UK offer you the chance to just apply for citizenship for the children, even if he has not spent 7 years in the country?
Yes, you can. So if you get your ILR status, you can apply together with your family. If they're under you, you can apply together.
Oh, okay. Thank you very much then.
I don't know if Gina wants to speak now, or I should read some of the other questions in the chat.
Yes, I can unmute now.
Okay.
Welcome. All right, thank you. Hi, Omotolu, thank you so much for this session. My question is, it's like Olu's question, but I think the further clarification I want to get is these are still the children in a situation where it's not a student visa, like parents that came in via Tier 2, and they have 5 years to stay under the Tier 2. And then this issue of, I've heard it in two folds. The children acquires the status the parents has, and then I'm hearing this 7 years route for kids. So with regards to Tier 2 visa, is it still the 7 years or still the status of the parents?
So typically what happens is when your children take up your status, typically. And the reason, if you see the example I gave for Olu, I started off with, if you came here as a student, like doing maybe your LLB degree, and then you have a child here, and then you went on to do masters, and then you went on to do PhD. Now, I was coming on at the student route. Do you understand? Now, typically for people that came here directly for skilled workers visa and then brought their kids here, like over. So most times they would, the position of the law is this: when you get your settled status, your ILR, you can make the application as well for your family, that way you're dependent. At the same time, you're making your own application, even though they've not met the full number of years. You can make the application together. They can still remain your dependent under. At most, even if the application, if the application is refused, they can still be your dependent under your ILR. Do you understand? But you can make the application together. Once you get the ILR, you can make the application for your children's ILR as well, if they joined you subsequently. Does that make
Okay.
sense?
Yeah, it does. And then a further clarification on still this towards ILR. I think I heard some talk about for someone like, okay, I came in as a student visa. I mean, on a student visa, I came in with my family, and then now we've switched to my husband's tier 2 visa. So I think there was this talk I heard sometime that for my dependents, their stay towards ILR starts counting when they were dependents on my student visa. Like now that we have switched to tier 2, so we have stayed for a year now in the UK. So it's assumed that they have stayed for a year, while I'm just starting my stay in the UK because I was the main applicant on the student visa. How true is that?
Sorry, can you repeat that question? I'm sorry.
Okay, sorry. Okay. I came in on a student visa with my family. They came in as my dependents. And then we've switched now to my husband's visa, tier 2 visa. So I'm a dependent right now to my husband's tier 2 visa. Okay, my question is, I said I had some talk sometime that their stay towards ILR start counting when they were my dependents. Meaning, okay. Oh,
No, your children, were they born here?
No.
Yeah. So typically what would happen in that instance is, they ideally were taking your visa status, which would mean that they took your visa status, and then when you switched to your husband's one, then they took his own. Is that correct?
Yes.
They took his own. So they would their stay towards ILR will start counting like that.
Okay, so everybody's stay towards ILR, it's counting at the same time.
Yes.
Okay. All right. Thank you very much.
So one question from the chat by
I think that will be the last question I'm taking today.
Okay. So he said, I don't know if my question was answered already since I joined late. I want to know if those on existing tier 2 visas can still bring in their dependent, especially for unmarried couples. And also, if I change visa route, would my 5 years start all over again?
Sorry, what question is this? Because I'm trying to look at the chat and I can't see that question.
So it's by Bobby, is 2045. You see like a BN in front of it.
How many questions? Sorry, can I ask how many questions do we have so far?
So far, or like that's left?
How many questions is left? I would answer all the questions that's left.
To that and one more question.
Okay, let's do that. So can you repeat that question again?
Okay, so the question is, I want to know if those on existing tier 2 visas can still bring in their dependents, one, especially for unmarried couples, and also if I change visa route, would my 5 years start all over again? I think it's a question.
First of all, what visa were you on?
So the person was on a tier 2 visa.
Tier
And
2.
yes, if they can still bring in dependents, right? Especially so from what I understand by the question is, the person is currently on a tier 2 visa and wants to bring in a dependent who is unmarried, right? Like an unmarried couple. And also, if that visa route is changed, would the person start all over again? So I don't know if what visa route could be changed to. So it's just like a generic.
Okay. So if you want to bring your dependent, maybe use your girlfriend and you guys are not married, what you would need to show is that you people have been together for 2 years, and you've been together for 2 years, and the way you've been together, it's like as if you were married. So typically, maybe you were living together before you then moved here, and there's evidence to show that you were living together. Let's say, for instance, you had joint bank statements together. You were paying bills together, and there's evidence to show that you're paying bills together. You have pictures together. You have you just need evidence to show that you've been in a relationship for 2 years, and your relationship can be likened to you being married. If you can show that, then you can make the application to bring them on as your dependent. Now, in relation to your second question, now, if you're on a tier 2 skilled workers visa, and you switch jobs, you're still your period is still counting because you're still on that same visa route. Do you understand? And you were the main applicant. The time will start again if you're going to switch visa as a dependent of someone that is on a tier 2. So you're no longer on a tier 2 dependent again. You're not on a tier 2 visa again. You're now a dependent of somebody that's on a tier 2. That's when your time will start from the beginning. But if you are still on that tier 2 visa, you're maybe just changing from one job to another, but it's still on the skilled workers visa, your time does not start again. It continues. So once you reach 5 years on that visa, you can apply for your ILR. I hope that clarifies it. If that's the question the person is asking.
I think that is. So to our last question for the day, because it's 2 minutes.
I see that Gina's hand is still up. I don't know if she wants to ask another question or this is just.
I think I didn't raise it down. So
Sorry, I'll take it down now.
okay.
Oh, that's okay. I wanted to be sure you had. Okay, that's fine.
So for the last question, it reads, please, what options are available to someone whose graduate visa is about to expire and the person has not gotten a sponsored job? This person has family members here with him who cannot join him as dependent. If he decides to do another master's program, okay.
Well, the thing is, if your graduate is about to expire, you need to either jump on another kind of visa that will allow you to stay here as a dependent. That's typically what I would say. So there, like I said, there are different visa routes that you could potentially switch to, as long as you make sure you do the application before your current visa expires. And before you switch into those visas, you have to make sure that you meet the criteria for those visas. You can't just throw in an application if you don't meet the criteria. But it's tough. Things are, I honestly, things are tough in this UK. I can relate. Honestly, I can. And all I can say is, please just keep applying to see if you're going to get a sponsored job. You know, that's all I can say regards to that.
Thank you very much for the insightful speech and the wealth of knowledge you've passed on to myself and everybody who is listening or who has come and then dropped off as well. As you already know, our guest speaker is Omotolu Oyewole, and our email is in the chat for people who want to go a step further for more person-centered consultation.
Please, we are going to I'm just gonna throw this out there. I charge for consultation.
Obviously,
So
obviously we know.
please, if you're going to consult with me, feel free to. I'm not expensive. I mean, I'm really not expensive.
Like we
That's
said,
my email. Feel free to reach out.
yeah, like we said, is not only this, there are some situations which would warrant you to, speak in details about what you're going through, and for our advice based on our experience to advise you on what is to be done or maybe assist you in filling an application, you'd have to consult Omotolu Oyewole on that. And like you said, every legal practitioner gets like a consultation fees for their services. What you would negotiate with her is based on like what Tolu would accept. And like you said, just try. Everybody has like negotiating power. But on behalf of Black and Proud Community Interest Company, we want to thank you and thank everybody who has been here today to listen to Omotolu. We hope you guys had your question
Oh God.
solved. So please do follow us on our social media platforms at Black and Proud CIC on Instagram. This video would be uploaded on YouTube, and then the link would also be shared for people to share to loved ones to also learn from what we have today. So right about now, Tolu, if you have like maybe a last minute shout out or anything you want to say.
Thank you, Dambi, for putting this together. Honestly, when you reached out to me the other day, I was like, I can't believe someone's reached out to me to do something like this. So there will be more webinars coming soon, and obviously we would definitely try and see if we can get a wider audience, and also would send out flyers and let everyone know. But for right now, honestly, thank you everyone for attending, and I hope I was able to answer your questions as best as possible. I hope you were able to learn a few things here. And it's important for us to, like I said, read the guidance. New updates are coming April 4, new updates are coming April 11, and definitely I would also be doing webinars on that to further explain and give insights on what the rules are. So, and if you want to consult, please feel free to my email address. I've just popped it in the group. And yeah, Dami, thank you for putting this together, and thank you everyone. Have a lovely, lovely evening.
Thank you very much. We've come to the end of the program. Do take care of yourself.